Hello friends, welcome to ixambee's law channel Legal B. In our last video we discussed the legal maxim actus non facit reum nisi mens sit rea, and I gave you a situation in which A asks B, who is 6 years old, to add liquid that is poison to the milk of C, which C drinks and dies. So who will be held liable? Will A be held liable or will B be held liable? And to which legal maxim this situation relates to? Here we are talking about the legal maxim Doli incapax. Incapax here means incapable, and the entire legal maxim means incapable of crime. That means incapable of doing any harm or incapable of committing a crime. Usually when we talk about this legal maxim, we are referring to a child who is incapable of forming the necessary criminal intention, the necessary criminal mind for committing an offense. And that is what we discussed in our example. This child B had no knowledge of the act that he was doing. He was asked by A to add poison. So here B being a child, he had no knowledge of the outcome of the act that he is doing. Hence he won't be held liable. A will be held liable under this act. A will be tried for the offense of murder. This maxim, Doli incapax, is incorporated in section 82 of the IPC. Section 82 of the IPC comes under chapter 4, which relates to the general exceptions. And section 82 talks about a child under 7 years of age. It says nothing is an offense which is done by a child under 7 years of age. तो अगर कोई बच्चा 7 साल से छोटा है तो उसे क्रिमिनली रिस्पॉन्सिबल हेल्ड नहीं कर सकते. Why? Because at this age he is incapable of distinguishing between right and wrong. As a result, the law confers absolute immunity from criminal prosecution, criminal trial or conviction of such child. एक 7 साल से छोटे बच्चे को ये नहीं पता कि उसके एक्ट का आउटकम क्या होगा. उसे गलत और सही के बीच का डिफरेंस नहीं पता. That is why a child under 7 years of age is given absolute immunity. Then we have section 83 of the IPC as well, which talks about Doli capax. That means capable of committing a crime. Section 83 of the IPC gives qualified or partial immunity to a child who is above 7 years of age but under 12 years of age. Here we are talking about a child above 7 and under 12, and it says nothing is an offense which is done by a child above 7 years of age and under 12 who has not attained sufficient maturity of understanding to judge the nature and consequences of his conduct on that occasion. तो अगर उसको समझ आ जाए कि उसके एक्शन का कॉन्सिक्वेंस क्या होगा, what is the nature of the offense that he is going to commit or he is committing, then he can be held liable. Section 83 therefore gives qualified immunity or partial immunity. There is a condition that has been included. There are certain important case laws with respect to this legal maxim. The first is Heera Malik versus State of Bihar. Now in this case, the Supreme Court upheld the conviction and sentence of a 12-year-old boy who was with his two elder brothers had been convicted of a murder, because it was held that there is prima facie inference that the appellant had the intent to endanger the life of the deceased, and such inference stands unrebuted. Moreover, section 83 was not invoked at any stage and no evidence was shown addressing the age of the appellant or his lack of sufficient maturity at the time of commission of the offense. इस केस में एक 12 साल के लड़के पर अपने दो भाई के साथ केस था. उन तीनों ने जाकर विक्टिम का मर्डर किया था, and the 12-year boy had inflicted cuts on the neck of the deceased with a sharp weapon in an act of revenge, and then ran away with his elder brothers. Thus, in this case, the court assumed that it can be prima facie inferred that the appellant, the 12-year boy, knew what he was doing. He knew what will be the outcome of his action. He had the intent to endanger the life of the deceased. And also section 83 was not even invoked. It was invoked later in the appeal, where it was said that he is 12 years of age, he did not have understanding, and it was not shown earlier that there was lack of maturity. And thus this 12-year boy was convicted of murder. The next important case is Kaku versus State of Himachal Pradesh. In this, a 13-year-old boy was convicted for raping a 2-year-old girl. And to bring down the sentence of punishment, Section 82 and 83 was used. The court kept the conviction but reduced the punishment. It has thus become a settled principle of law that juvenile offenders should be dealt with a humanitarian approach and steps to be taken to ensure reformation of the child. Thus, via this case, an important principle of law was set that the juvenile offenders should be dealt with a humanitarian approach and reformation of the child should be ensured. This principle is also stated in Juvenile Justice Care and Protection of Children Act 2015. In that act also, emphasis is on the reformation of child and dealing with juveniles with a humanitarian approach. Now moving to our next situation. Let's take another situation for another maxim. A is a person. He has invited B to his home for dinner. Now after B has come to A's house, can A accuse B of trespass and can A file a suit against B for trespass? And guess to which legal maxim this situation relates to. iXambee is your one-stop solution for all legal exams preparation. We offer online courses for banking law officers, for insurance law officer, for Coal India legal officer, for Scale 2 banking law officers, and for regulatory body law officer exams. If you are interested, if you want our guidance, you can check out the demo of these courses from the description below. For any queries, you can write to us at hello@ixambee.com. You can call us on this number mentioned on the screen. Subscribe to our channels to stay updated with enriching legal content, notifications, strategies, study plan related videos. Thank you.